Our run showcase today is Mr. Rogers is a business attorney who focuses on helping clients buy and sell small businesses. He regularly helps his clients set up new companies, which often involves navigating trademark law as his clients decide what to name their companies. In this morning's presentation, Brian provides a helpful overview of trademark law and how it impacts small business. Thank you, Brian.
All right. I got a laugh out of the Mr. Rogers thing. I always like being in a group where that actually people understand. As I get older, when I was young, I hated it. Mr. Rogers.
Welcome to the neighborhood.
So, but it could be a nice icebreaker. So, but welcome to, I don't know, midlife maybe for all of this. So.
And you even have the sweater on, right?
Yeah, exactly. I should have brought another one. I could change it.
Can you go ahead and change your shoes?
Who are you talking to?
Feeling right at home. So, well, most of you probably know me as an attorney that helps people buy and sell businesses, but a big part of what I do in that practice is help people set up new companies. When you buy a business, normally you don't buy the company, you buy all the assets. So you set up your own company, buy the assets. So that's a big part of my practice. And an important early decision for business owners when they're setting up a new company is what to call their business. And I'm licensed in Missouri and Illinois, and in both of those states, as in maybe every other state, every one that I'm aware of, every company has to have a unique name. So, if you've got a plumbing business and you want to name it, say, Acme Plumbing LLC, if there's another plumbing business in Missouri that's named Acme Plumbing LLC, you can't call your business that. You can't, as far as a legal name. And so you have to, call it something else. And that applies not only to LLCs, but corporations, limited partnerships, any business that is formed by filing a document with the Secretary of State, they all have to have a unique name. Now, that doesn't mean that you couldn't use the name Acme Plumbing LLC when you're doing business in Missouri because of fictitious names. So Missouri, along with just about every other state, allows you to do business under a name other than your legal name. So just because you can't create a company called Acme Plumbing LLC doesn't mean that you can't file a fictitious name. It's also known as a doing business as name or a DBA. And one good thing about Missouri is any number of companies can have the same DBA. So if you look in the Secretary of State's records in Missouri for, say, Subway, there'll just be page after page after page of Subways because of, the sandwich shop. So Illinois, they regulate the names, fictitious names, just like they do legal names. So you can't do business, you can't register a fictitious name in Illinois if there's another company. But anyway, but regardless of all of this, what's really important is trademark law. Because just because the state will let you create a business with a certain name, or just because it'll let you register a business under a certain name, doesn't mean that you're not infringing on somebody's trademark rights. So that's what we're going to talk about today. And this is just a quick overview of what we'll be covering. So what's a trademark? The fact that trademarks accrue automatically when you start using a mark. Categories of goods and services. Trademarks are specific to industries. Geographic areas. Geography matters a lot in trademark law. First in time wins, the importance of federal registration, and then a little bit of discussion about choosing a name for your business or the brand. So first of all, what's a trademark? It's a word, phrase, symbol, design, or a combination of those things that identifies your goods or services. So we normally think of trademarks as intellectual property, something that you own, but the the core purpose of a trademark is information to the market that this is the source of goods or services. So, and I'm using trademark kind of generically, but more properly, trademark refers to goods, products, and service mark apply to services, but we normally just use trademarks for both trademarks and service marks. And I won't go into what a trademark is in too much detail, but it is interesting that even scents and sounds and other things can constitute trademarks. So now, when you, man, I'm already getting the clock. That's quick. Get a hook here in a second. From going too long. I'm used to that. So when you start using a mark in commerce, you're selling goods under a certain name or providing services, you automatically have trademark rights under the common law that accrue to your business. So just by virtue of using those marks in your business. And you can, tell the world that you're claiming that mark by using a TM symbol or an SM symbol. Or if you register your mark, then you can use the little circle R symbol once the U.S. Patent and Trademark Office issues a trademark registration for that mark. So going back to our plumbing business, when you set up shop as Acme Plumbing LLC and say you're selling plumbing products, then trademark rights will begin to accrue automatically without you really having to do anything. So now those trademark rights are specific to categories of goods or services. So if you're Acme Plumbing, sold plumbing products, but then there was another Acme Plumbing that sold plumbing services, those are two different industries and they're probably not going to infringe on each other. So you can have two Acme Plumbings that can coexist without infringing each other's trademark rights. So, and a good example of that is Delta. There's Delta Airlines and Delta Faucet, and they can coexist without infringement because they do different things. So one does faucets and one does plumbing. So another important aspect of trademarks is that they're specific to geography. So going back to our Acme Plumbing, you want to set up a plumbing shop in St. Louis, but there's a plumbing shop called Acme Plumbing in, say, Columbia, Missouri. That's not going to be problematic because the trademark rights that accrue to Acme Plumbing in Columbia are going to be specific to where they're doing business. So if they're not already doing business in St. Louis, then you're not going to be infringing on their common law trademark rights. So not only do the categories, so there may be selling goods versus services or whatever, but geography is also important. And there's a really fascinating example of that in Mattoon, Illinois. If you go to Burger King in Mattoon, Illinois, it's not going to be the Burger King that you're used to seeing because there's a family-owned restaurant that's been doing business under the Burger King name since the 50s. And so when the national franchise out of Florida registered their trademark with the U.S. Patent and Trademark Office, it didn't give them rights to override the common law trademark rights of this Burger King family-owned restaurant. So Burger King the franchise can't put a restaurant within 20 miles of the restaurant in Illinois. So geography is important, but that also illustrates another important aspect of trademark law, and that's that time is important. So first in time wins. With the Mattoon, Illinois Burger King, they have precedence and have the rights over the national chain because they came first. So they had registered their trademark with the state, But more importantly, they've been in business using that name for quite some time when the national chain filed a trademark application. So, speaking of trademark applications, there is federal trademark protection that's available to you. What I've been talking about is largely the common law. It's kind of the natural trademark protection that has protected trademarks, for generations. But you can register your mark, again, within a specific category of goods or services with the U.S. Patent and Trademark Office, and that gives you precedence nationwide as of the date of your trademark registration. Now, as we've seen with Burger King, that doesn't mean that if there's already somebody using that mark in your category of goods or services, you can't override their existing rights. But it does give you priority for the rest of the nation as of the date that your registration is active. So if you're thinking that you might go national with your new business or your brand, then you might want to register your trademark with the USPTO. So in thinking about whether you want to register in the conversations that I have with my clients, I think about it both defensively and offensively. And from the defensive perspective, or the offensive perspective, if it's important for you that nobody else in the country, certainly not in your markets, do business under the same name that you're doing business under, your brand, then you might want to consider registering your mark, because then other people could later come and start doing business under that name. And if they did, you would have legal remedies. But defensively, it's important to think about, what if someone comes along and asserts trademark rights in your brand name? Would that be disruptive to your business? A lot of people's businesses, it wouldn't matter, just change your name. I've gone through this process with a few clients that get a cease and desist letter, and they end up changing their brand name or their business name. How disruptive would that be? And these are some of the questions that you can ask. Is your brand important for your marketing success? If so, it's probably a good idea to do a federal registration. If you're selling products and they have your name stamped on them, it'd be very expensive to throw out all those products if you have to change your brand name because of trademark issues. In that case, you probably want to expend a lot of resources making sure that this brand name is safe and including registering it. So, and same as far as marketing materials, if you've got a physical location, you spend $20,000 putting a sign out front, you probably don't want to have to change that if you have to change your name. And then also, are you planning on doing business nationally? Because if you are, then your common law trademark rights only accrue where you're doing business. So each time you go into a new area, your trademark rights would start to accrue. In the meantime, somebody else, might be setting up shop, in Acme Plumbing in one or more areas, and you could have the same issue that Burger King had. So just I'm down to 2 minutes, so I'll just go quickly talking about naming your business. When you're thinking about naming your business or your brand, it's important to see what else is out there. So Google search, I mentioned earlier the Secretary of State. In Missouri, it's sos.mo.gov. Just search under the search business tab, and you can see if there's anything in use. Of course, Google is helpful, and really I would recommend going to your local library because there just are awesome librarians there that can help you out for free. So
They'll do all the research for you.
they'll do the research for you. So, and then just a quick word about the strength of trademarks. They're not all created equal. So the strongest trademarks are what the law calls fanciful, but they're just made up words. So basically on the kind of continuum of strength, the more creative your trademark is, the stronger it is, the easier it is to protect it. So made up words are the best. Exxon, Pepsi, Polaroid, those are examples of fanciful trademarks. Arbitrary, so who would ever associate Apple with computer products? I mean, everybody now, but you know, when they started, of course, it's using Apple to brand computer products is arbitrary. It has nothing to do with the, you know, qualities of the computer. So the closer you get to actually describing your goods or services in your mark, the weaker the mark. So suggestive would be like Coppertone, and you know, I suggest you're going to be darker. You know, when you use the product, you'll tan. So it doesn't actually name a quality. It's not descriptive, but it's suggestive of a certain quality. So those three are all strong trademarks. Descriptive is not strong, and you might even have trouble getting the USPTO to even issue a registration if it's descriptive. So if your name of your company is creamy yogurt, it just describes the quality of the yogurt. And generic are not really even trademarks, and they're not registrable. You can't protect them. So if you're just describing your product or your service, then it's just not gonna be protectable. And I'll leave you with an interesting vocabulary word for trademark that I think is interesting, and that's genericide. And it's basically a trademark that's so strong that it becomes the name of the product. So like Band-Aid or Kleenex. I'm not saying that those aren't good trademarks, but that's an example of what can happen to a product where it becomes a noun instead of an adjective, and it becomes the name of the product. So now, I personally would love to, hope everyone didn't hear that. I personally would love to have such a strong brand that it became, the name for lawyer. If they hired a Blue Maven instead of a lawyer. But that's not really good for trademark protection. So I'm sure I'm out of time, so I would entertain any questions. Sir, I do have time for questions, right?
5 minutes.
5 minutes. Les, I'm sorry.
So could I literally take a name like Google, call it Google Real Estate or Microsoft Clothing Apparel? Those are exaggerated examples, but is that legally feasible?
So that's in the advanced course that I charge for. Yeah, that's so those are examples of famous trademarks, and once a mark gets to that that level of recognition, you're going to infringe on it no matter what you do with it. So you can't put a swoop on something that has nothing to do with Nike and you think you can get away with it. So. Yes, sir.
Just a point for everybody in the room. There are new requirements by internal revenue as far as your business and getting all of the particular information about your business so they can come and visit you. So check with your attorneys to make sure of what you have, and watch it, because there's certain openings for certain times that you've been in business.
Yeah, that's a great public service announcement because it's a law, the Corporate Transparency Act, that was passed some years ago, went into effect January 1st of this year, and it just hasn't gotten a lot of
Traction.
publicity. Yeah, so people don't know about it, but if you have a small business, even if it was formed before the law went into effect, there's certain federal requirements. So talk to your Blue Maven or your CPA.
I was gonna say, if we're just talking beneficial ownership, it's really easy to go online and just fill out the form for the feds. And I think if you were in business prior to this year, you had until the end of this year to file it. But if you would open a new LLC or S corp this year, you've got to file it immediately,
30 days.
30 days.
So you've got, you're correct. If, for a business that was already in existence as of January 1, 2024, you've got the whole year. For businesses that are formed in 2024, you've got 90 days. For businesses after that, you've got 30 days. And you also have only 30 days to report changes. So anyway.
What is it we're filing?
Beneficial ownership.
Thank you.
Yes.
I have a question as it relates to filing for a name versus a logo versus like a tagline. Is that all encompassed in one, submission for trademark, or do those have to be individually? How does that work?
Yeah, there's two different ways to file a trademark. One is standard form, and that's just the letters in no particular, design or anything. But you can also do a special form, trademark registration that would include designs, logos, particular scripts. With Coca-Cola, it includes the bottle, because it's a distinctive type of bottle. So,
Do they have multiple, like Coke owns like
yeah,
a ton of different
yeah,
logos?
I couldn't imagine.
Polar bears and stuff like that?
Yeah, I can't imagine what the
And it's
portfolio would be like.
too, based on
Yeah.
all of their product lines.
Yeah, yeah. So you could be in a situation where, it's a good idea to, file more than one mark, so. Just someone else?
Just real quick, so we have a trademark on Zoplex, so we're famousful, so it's made up word, so that's good, right?
All right, yeah.
So there is though a German pharmaceutical company that's using Zoplex. It's not really out and we don't even know if it's really active. How does that work? I mean, obviously it's a US trademark, but how does that work internationally?
Yeah, there's, well, I can get out over my skis really easy here, so I'm not a trademark lawyer. There's a convention, a treaty of sorts that 100 or so different nations are a party to. And that is one way to get protection beyond the United States. Although as I understand it, just registering with that doesn't necessarily give you trademark protection because each country may have its own rules. But yeah, what have been talking about is U.S. trademark law and protection. So if you go, and also, I said one thing that's important about U.S. trademark law is that when you begin to use a mark, you automatically get trademark protection in that mark. Some other countries are not like that. The first to register gets priority. And so China, I think, is in that category. So if you're doing business in China, it's important to make sure that your business partners in China can't register your mark or lose your product. So, and one last thing I wanted to say about choosing a name is that there can be a tension between a strong trademark and SEO, one that's effective for SEO, because again, I could get out over my skis really easily on this, but description is good for SEO, like St. Louis plumber, for instance. That'd be a very weak mark if it's even protectable at all. If you make up a word, Google's not going to associate it with anything. So until you get traction with your brand name, it's not going to give you a lot of help with SEO. So I think we have one more. My time is up, but I'm gonna.
Go ahead. Do really quick.
So the registrations, are they something an entrepreneur can do themselves, or if they need consult from a person like you, what does it cost?
We definitely have to hire a lawyer.
Yeah, that's kind of what I figured it wasn't Steve free.
I did register Blue Maven Law when I first put out my shingle. I had decisions of national. And then I realized how much I enjoyed evenings off, and so I did hire a lawyer, even though I know enough to make this presentation. So, and I don't do trademark registrations for my clients. It's just, to me, it's a specialty. There are trademark lawyers who specialize in that are a lot better their pricing is better than I could provide because they do it over and over. So you can do it yourself. The USPTO website is a good source of information, and they actually discuss whether you need a login or not. So I'd refer you, I guess, to that.
Thank you, Governor. I just want to make a quick comment. There was a very, very popular cookie dough business here in Chesterfield Valley that recently shuttered. The reason it shuttered was because they got a cease and desist order because they did not do the search up front. And they built their business on a particular name that was protected.
Oh, wow.
Yeah,
And had to shutter the business.
Yeah.
So this is important stuff. You know, you talked about putting a sign out front. They put a sign out front, a lot of advertising, and had a very large, nice business.
wow.
That's what it got noticed too.
Yeah.
So on that positive note,